My appraisal also. Lordship, in item number 4, I am seeking an accommodation for 2 weeks. Item number 4. 4. I am for the respondent in this case. I have
Okay.
taken the consent from the appellant.
4 or 3?
Or
Sorry,
Three.
three.
3.
Sorry, sorry.
3.
3.
You are for?
I'm for the
Appellant.
respondent.
Okay. MS
S. Katwani.
S. Khatonia. Learned counsel for the appellant. Is present. Mr. D. Choudhury, learned counsel for the respondent, has sought listing of the case appeal after 2 weeks. From which is agreed to by MS Khatonia. Learned counsel for the appellant. Place the case after, place the appeal after 2 weeks. Needed.
Much obliged.
Daily list for orders, item number 1.
Next leader lordship, I am the informant lordship. Till that this IA copy has not been served to
Okay.
me lordship.
You want a copy of the IA
IA lordship.
and
We have filed an objection.
objection. He needs the objection also.
Yes,
He also
Yes,
wants
sir.
to file objection, he's saying.
Okay. You want a copy objection also? Your counsel, you are a bit,
My lord, my senior is on his way to this court, my lord.
anyway,
Lordship, earlier there was a direction to prepare the paper book.
yes,
Okay?
under preparation. Under preparation. Your Mr.
My lord, A. Ahmed.
Hmm?
A. Ahmed.
A. Ahmed. Your name is A. Ahmed.
Your senior's name is Ahmed.
Yeah, my name is.
Your name is.
Okay, you are also A. Ahmed.
My lord, my senior is on his way. He want to start something.
That does not mean court has to wait. Anyway, he needs a copy. At least, Kabel Mia is the informant.
Yes, sir. Father of the victim.
Yeah,
Yes.
learned counsel for the applicant appellant. MS B. Punya, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty. For the respondent number 1, state of Assam. And Mr. N. Ahmed, learned counsel for the informant. Yes. Respondent number 2. Mr. N. Ahmed, he is appealing for the informant. He says that he wants to file an objection. And also he does not have the copy of the IA.
They earlier appeared. Actually, they're 2 dates gone. They filed long back their Wakalatnama. I thought they would not fight. They could have informed me at the initial stage itself when they filed Wakalatnama and appeared before the court, Lordship.
Now he is saying,
After going
Please,
through dates, Lordship, they are now seeking their.
right. He says the right.
Yes, right. I am not disputing that.
Not
But
declined that. How much time? 1 week? 1 week. Next Monday. Say date, March or April first week,
March.
Yeah,
Lordship.
March 27th.
27 plus.
Yeah, I'm application, no? Okay, Mr. N. Ahmed, learned counsel, appeal for the informant respondent number 2 as submitted that informant respondent number 2 will file an objection to the interlocutory application and a copy of the interlocutory application be furnished to him. Mr. A. Ahmed, learned counsel for the applicant appellant, will furnish a copy of the application to Mr. Ahmed within 2 days. Within 2 days. You need anything?
No, lordship.
Okay. The informant, that's respondent number 2, shall invariably file its objection on or before 22/3/2021, 21/3 21/3/2024. So to place the case on 27.
Oh, hearing item number 2.
Madam, what was the মই আপুনি মই এনেটো পেট্ৰল চলিছো মেডামকো দিয়ক মই আপোনাক চেঞ্জ কৰিছো Yes.
Lordship gone through the paper book. I think all witnesses are turned hostile.
How to deal with a hostile witness?
His
How to
lordship
deal
has
with when
already,
How is the law?
law
Well,
is, it has to be supported by independent witness. When he is cross-examined,
So far, say for example, if you take the paper book, which one? Say PW1. Do you have the paper book?
actually I'm having a part-time matter, so I gave it to Miss Sapna. She has not arrived yet.
Okay.
She's late.
Now suppose after seeking permission by the prosecution,
Yes,
if that is allowed, then prosecution cross-examines a witness.
my lord.
Then in the cross-examination, the prosecution has brought the thing that you, in your previous statement, have stated like this.
Yes,
And that was also put to the IO,
IO.
right? So what is the law there?
Actually, IO should bring it along with him, the case diary. He should show it to the witness concerned. He should mark it. Have you stated before me like this? So, but nowadays it's not performed, my lord. As per Tahsildar Singh's case, it has to be done like that, my lord. Lordship, but in the most cases they don't do like that. Lordship, but it has.
1958 or what?
Yes, my lord.
Tahsildar?
Yes, AR 1958.
Oh, yeah.
lordship has passed in 2020 jailer judgment. My Lord Justice Mir Alfaz Ali.
Huh?
With Mr. Justice Mir Alfaz Ali, your lordship has passed an judgment.
I have forgotten.
2021 GLR, I think.
Okay, so
Pavitra Rai. 2021 GLR 689.
Takes few days to come back.
And that is exactly the case in hand.
Tahsildar Singh's case, no dear, equitable beside.
1958.
Yes,
right?
AR 1959, SC 1012. Tahsildar Singh versus State of UP.
2021 GLR 689. Paragraph 13 onwards, the same case.
Oh, Dangor. Oh, Dangor.
Which paragraph?
Paragraph 13 onwards, my lord, the case.
You can say the Tahsildar, which paragraph?
Lordship, paragraph not written. There's 24 Nikki case, 24 onwards. AI 1959, SC, DS one, etc. That's our room, it's very like, Thanks. Lordship, AI 1959, SC 1012. 59. Then your lordship, 1989, 2 criminal law channel 320. All this like how the contradiction has to be proved.
No, my question is,
Yes,
this portion of evidence
yes,
by the cross-examination by the prosecution
my lord.
and which has been put to IO also, whether this is to be taken into account or not to be taken into account. And
Yes,
how?
Yes, my lord. The question put to IO that it was made before him. The statement was made before him. It may be taken into account, but coupled with it, it has to be corroborated by an independent
Right, right.
witness.
No, but how it is to be taken into account? It will be a contradiction,
It will be a contradiction, my lord.
right?
Yes,
Because he is saying in the witness box something else.
yes. So,
And he, before the IO,
yes,
stated something else.
else.
So it is contradiction.
Yes.
So it should be, it should not be taken
We
up,
cross-examine him, my lord. Our own witness, we cross-examine.
right?
Yes,
So now by way of cross-examination, what the generally defense does,
yes,
you have cross-examined
my
him
lord.
and said that in exhibit 1 FIR, in your previous statement, you stated like this. He denied, right? And when IO came, you put the thing again to him.
My lord.
He said that, yes, in the FIR, he stated like this. And in his previous statement, he stated like
Like this.
So that makes the statement in the
In
chief,
161, yes.
in his evidence, a contradiction.
Yes,
So since it is a contradiction, so whether we should take into account anything from that.
yes, your lordship may take into account that part, but in case of hostile witness, my lord, the
Yeah.
witness turning
Well,
hostile.
we are only
Yes.
dealing with hostile.
Hostile. So
That
lordship
part
may not take into account unless it is for my limited knowledge, my lord.
is what
uh,
I am.
Lordship, it has to be supported by an
That I
independent
know.
witness.
That
Yes.
I know. But
My lord.
how to treat this part?
Then we cross-examine what it comes from his mouth, my lord. In cross-examination, what he has
One
stated.
part is his evidence in chief,
My lord,
right?
my lord.
Then you took permission from the court
Lord,
to cross-examine your own witness,
my lord.
right?
Yes,
Then that is the second part.
yes,
Second part
My lord.
is evidence.
yes,
Page 10,
yes,
right?
yes,
Second part, cross-examination by prosecution.
yes,
Okay. Then third part, cross-examination by defense.
my lord.
Now, second part. I'm talking about this second part. And you have put this part to the IO.
IO,
So as a result, this second part coupled with the IO's evidence part, that makes this thing contradiction,
yes,
right?
yes,
So if it is contradiction, whether we should take note of this part for the purpose of Appreciating
proving
the evidence,
of,
qua the charge.
yes, my lord. Lordship, evidence to be taken as a whole.
No. No. Then come to the IO. No, come to the IO then. Who is the IO?
IO is, my lord, PW, oh, sorry, my lord, PW six, page 22.
Page 23%.
I said. Where do you know? বুঝিলে দেখি কিতাপ পঢ়া না ভাল লাগে মুতা টাইমিং কৰিব দিপেন মন দেখছ Lordship 2015 9 SCC 588.
So I think IO should have been shown the part in the case
Hey,
that
don't do, my
and
lord.
should have been
Why?
marked. What does Tehsildar says?
Tehsildar, it should be marked.
Let us see.
With the witness.
The
Lordship,
paragraph.
one more judgment, VK Mishra's judgment, my lord. 2015 9 SCC 588.
Which part?
Uh,
Big one.
Not that big, I think. Para 14 to 16 and 17 and 20. মূল এটা ওলাব। You took those.
And if this goes,
Hello, nothing remains.
nothing remains.
No, no. Because
Except
one of the fact,
that man also died after a few days.
yes. Lordship, one more factor, they are related. Father was killed by a brother. So naturally, my lord, it's a natural instinct.
That situation
Lordship.
And see, but
আৰু
legally how
জেলত
to
আছে
deal
নেকি?
with it.
জেলত আছে নেকি?
Jailot assistance
Already lordship.
since 2017.
Uh,
My lord, there are few other points which needs attention of this court. The daughter of the deceased, the sister of the accused person. Here, the PW one says that she accompanied the when he was carried to the hospital, but the IO has not examined her to
What
take
happened
out the
today?
actual
What
what
happened?
has happened.
because
And the OC,
that's
officer
the
in
line of
charge,
photo.
he who directed him to investigate in the matter, he was not also examined. And no other person apart from the family members were brought in the witness box. And another thing, this person, the deceased, he was in GMCH since 21st of May 2017 till 3rd of June 2017 for around 14 days.
Who?
The deceased person,
Yes, yes.
but police has not taken any statement of the victim.
Paragraph?
Lordship, paragraph 14 to 16,
Hmm.
17 and 20. Para 18, 19, 20 also. No?
Right.
28 space. Become sure. Even the IO has to be confronted with my no, as to the statement made by the witness person. There is no cross examination to that effect, man.
Hmm. Steps on the line.
No, my full choices. Between Tarapur, 16, 17. 16, 17.
So here his attention was, PW's attention was not drawn to that part
My
of the 161 statement
Yes.
in the case diary. And he was not confronted with them. It was only a suggestion.
Yes.
Suggestion was put. And it was put to the IO.
I,
My lord.
But IO was not shown that part
Yes,
from the
ma'am.
case diary.
Yes, my lord.
So this, after declaring him hostile, prosecution has just suggested it.
yes,
My lord.
it's not a fact.
It is not a fact.
Yes.
Just put a suggestion.
My lord.
But his attention was not drawn to that part of the previous statement
Then, my lord.
where he said that my brother had stabbed my
Yes.
father.
Yes.
That part, 161 statement was not shown to him and it was not marked to him.
My lord. They don't.
So
know.
that declaration of hostile
My lord.
has not served any purpose.
Exactly.
since the procedure has not been followed.
So that cannot be, we cannot go into the 161 state,
Yes.
Yes.
Barred by.
but by 162. No, madam.
Lordship, there are other judgments of honorable,
So
dishonorable
This is
court.
clear, this is
Yes.
clear now. Memories got refreshed.
Refreshed, my lord. Abdul Qadir judgment, my
So
lord.
It is okay.
Right.
This was quite good. BK Mishra.
My lord.
This has elaborately explained everything.
My lord.
So, how many witnesses?
Five.
7 witnesses.
Seven.
Out of 11, 7 witnesses.
PW1 is
The son of the deceased,
and
brother
younger
of the,
brother,
brother of the
younger brother.
younger brother.
And 2 is sister-in-law.
To his sister-in-law, wife of the complainant.
3 is
Mother.
mother,
Mother.
doctor.
Who conducted?
This doctor is autopsy.
Yes, mother.
PW5
5 is a cousin brother of
Cousin
accused.
brother.
also hostile.
How, no, he has not seen anything. He heard.
Okay.
Yes.
And PW7,
He's the
Six
IO,
is the IO.
IO.
and 7 is the
PW6.
second IO.
PW6, IO.
IO. In fact, my lord, in the judgment of the Learned Trial Court at page 43, paragraph 53,
Okay.
43, paragraph 53, the Learned Trial Court also expressed this. It has been already found that the occurrence took place on 25th of May 2017, while the victim succumbed to injuries on 3/6/2017 at GMCH. PW6 did not take any step for recording the statement of the disease during the 11 days of occurrence. Had the statement been recorded by the IO, it would have been a great help for the prosecution to easily prove the case. The negligence on the part of the IO, PW6 is highly deprecated. So,
Heal from jail. Jail.
jail. Since 20
Lordship. Although all the evidences against us, against the prosecution, Lordship, one of the factors Lordship may take into account, the occurrence had taken place in the courtyard during the may not be four corners, but it was adjacent in the vicinity of the four corners or within the campus. So in that event of the matter, there are judgments, but when the witnesses like incident has taken place within the four corners, that every member of the family has to give some explanation as to the occurrence, Lordship. Even the accused person, Lordship. But here in this case, it's in the outside.
When
the courtyard.
outside,
My lord, page 55 is the sketch map.
I've seen. It appears to be outside
My lord.
Outside the home of the informant
on the drain near the road.
road.
So that
And there are
No neighbors,
6-7 neighbors are
no
there.
neighbors.
Nobody has seen.
IO said when he knocked, nobody opened the doors.
Right.
That is what his version is.
no sure. I don't think we have a case. And he has already passed how many years?
17 since 17.
Since
18,
17, he is behind the bars.
18,
6 years
19.
or so, how many?
Oh, during heavy
Under 20,
on the trial, no? Oh.
21/5/2017.
Instant appeal.
The lordship permits, may I leave, my lord? I'm having a part-time matter.
The instant appeal under from bill is directed against a judgment
Page 33.
Judgment dated 3/8/2019 and order dated 5/8/2019. Right?
Yes, ma'am.
Passed by the learned additional sessions judge Nogam.
Number 1.
Number 1. Where it is written?
In page 45 below.
Okay, number 1. Comma. Nogam. Within bracket. The trial court for short. In sessions case number 20 of 2018. Full stop. By the said judgment and order. The accused appellant has been convicted under section 302, IPC and sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 2,000, in default of payment of fine, to undergo further rigorous imprisonment for 4 months. Para. LCR to devotion. The investigation was set into motion with the institution of a first information report by one Sri Pankaj Hazarika, within bracket, PW1. Before the officer in charge, Samoguri Police Station, on 21/5/2017. Post of in the said FIR, the informant, that's PW1, had inter alia stated that the accused appellant who is the elder brother of the informant, that's PW1, had been asking for money from their father, which the father had received in respect of construction of national highway. Post up. The FIR had further mentioned that the accused appellant later on, signed an agreement that he did not want any part of the compensation amount. First of- It was alleged that at about 5 a.m. on 21/5/2017, the accused appellant quarreled with his father, again in connection with the compensation amounts in respect of commission amounts. And in the process, he suddenly bringing a knife from his house, stabbed his father in the abdominal part of his body and abdominal and other parts of his body in the courtyard. So as a result, the intestine of their father, what is his name? What is his name?
My lord,
Anestor Hazari
Anestor,
came out. Full stop. The informant PW2 had further stated in the FIR that they took Thaneswar Hazarika to Samoguri Primary Hospital. Right. Primary Hospital immediately, but finding his condition critical, the doctors there referred him to Nagaon Civil Hospital. Full stop. The injured was accordingly taken to the Nagaon Civil Hospital, but therein also, finding the condition critical, he was referred to, the injured was referred to the Guwahati Medical College and Hospital. Full stop. At the time of lodging the FIR, the injured, Thaneswar Hazarika was admitted in the GMCH. Full stop. As per the FIR, his condition was serious. Full stop. On receipt of the said FIR, the officer in charge, Samoguri Police Station, registered the same as Samoguri Police Station case number 277/2017 for the offense under section 326, IPC. And full stop. The officer in charge, Samoguri Police Station, had thereafter entrusted the investigation of the case to PW6. Full stop. Sorry, full stop. PW6, Modern Hood, Assistant Sub-Inspector of Police, had accordingly took up the investigation. Full stop. Where the investigating officer of the case, PW6, upon completion of investigation, submitted a charge sheet. Being charge sheet number 299 stroke 2017 dated 39/2017 under section 173 within bracket 2 CRPC, finding a prima facie case under section 302 IPC against the accused appellant as the injured, Thaneswar Hazarika, expired, in the meantime, on 3/6/2017 at the Guwahati Medical College and Hospital, right? Post on submission of the charge sheet. He was all along when he was arrested.
All along.
Oh.
Since first.
The
first-
accused, he surrendered perhaps.
Surrendered.
The accused appellant surrendered before the officer in charge, Samaguri police station on the date of the alleged occurrence, that is on 21/5/2017. এইটো আগতে লিখিব charge. On submission of the charge sheet, the learned judicial magistrate first class, Nagaon, upon causing production of the accused appellant from the jail custody, furnished copies to him as per the provisions of section 207 CRPC and as the offense under section 302 IPC is exclusively triable by the Court of Sessions, the learned judicial magistrate first class, Nagaon, committed the case records of PR case number 155/2018 arising out of Samaguri police station case number 277/2017, by an order dated 16/8/2018,
16-2.
16/2/2000, and by taking post on receipt of the case records of PR case number 155/2018, the Court of Sessions registered the same as Sessions case number 20/2018 and transferred the case to the Court of the Learned Additional Session Judge, number 1, Nagaon, for disposal. Full stop. After causing production of the accused appellant from custody, the learned trial court. Additional section. Better. After hearing the learned learned public prosecutor and the learned defense counsel, and after perusal of the materials on record, framed a charge. Is a charge order.
Page 6
It's instruction.
Framed a charge
and 7.
Under section 302 IPC against the accused appellant. So the charge was accordingly read over and explained to the accused appellant, to which he pleaded not guilty and came to be tried. So during the course of the trial, the prosecution examined seven number of witnesses and exhibited five number of documents in order to bring home the charge against the accused appellant. Full stop. The prosecution witnesses were लिखिए जो a index or 1, 2, 3, 4, 5 index of and documents that were exhibited were case 44. Okay. Exhibit 1, Ejahat apparent. Exhibit 2, postmortem examination report. Exhibit 3, format of the affair. Exhibit 4, sketchmate of the place of occurrence. And exhibit 5, charge sheet. Heard Mr. Edhor. Oh, no, before that. After closure of the prosecution evidence, the accused appellant was examined under section 313 CRPC and his plea was denial. Denied. Full stop. The defense did not adduce any evidence. Full stop. After hearing the learned counsel for the parties, Commander learned trial court, and after appreciation of the evidence on record and hearing the learned counsel for the parties, Commander learned trial court had found the accused appellant guilty of the offense under section 302 IPC, and he was sentenced in a manner indicated above. Full stop. I have heard Mr. Edhor learned amicus brief for the appellant and MS. Message for Learned.
We always appearing, my senior B, we always appear.
Okay. MS B. Via learned senior counsel and additional public prosecutor. Assam. For the respondent, state of Assam, assisted by MS M. Chakraborty, learned counsel. Assisted by students. Post of Mr. Thor, learned amicus appearing for the accused appellant, has submitted that the other than the doctor, PW4 and the two investigating officers, PW6 and PW7, the other prosecution witnesses, that is PW1, PW2, PW3 and PW5 are witnesses, are persons, who are related to the deceased and the accused appellant as the deceased and the accused appellant were the father and the son in relation. Post op. He has submitted that none of the said witnesses supported the case of the prosecution, as all of them had denied seeing the accused appellant stabbing the deceased contrary to the version mentioned in the affair. In affair, it was said that right?
Yes.
Full stop. The prosecution cleared all the four prosecution witnesses hostile. And thereafter put them through cross-examination. Full stop. Even in cross-examination, even by cross-examination, the prosecution could not elicit anything from them in support of the prosecution case. Full stop. It is his contention that other than there were no other supporting materials which could prove that which would establish that the accused appellant was the perpetrator of any attack on the deceased. Anything?
My lord, in the cross-examination by the defense side, in page 10, the informant also says the HRA was not written by him, it's written by a different person, and he has not read the HRR. Page 10 below.
uh, the informant, that's PW1, had page 10 below, had deposed that the FIR was written by a different person and he did not read the FIR. FIR was FIR to bracket of exhibit 142, huh? Exhibit.
Thanks.
Para additional public prosecutor has supported the findings of the learned trial court with the contention that what is the PM?
Lordship, Lordship. Oh, page 48, Lordship.
With the condition that the postmortem examination report within bracket exhibit
Exhibit 2.
had clearly reflected that the disease sustained number of incised wounds in various parts of his person, like the stomach, comma, elbow joints, etc.
Arms.
Full stop. such injuries were clearly results of assaults, and the autopsy doctor and the PME report in the PME report, it was clearly opined that the injuries were antemortem and caused by sharp pointed weapon. The learned additional public prosecutor has thus contended that though the death of the disease was due to septicemia, but septicemia was the result of the injuries, antemortem injuries caused by a sharp weapon. Full stop. It is a contention of the learned additional public prosecutor that it is a contention of MSP that the prosecution witnesses who had resigned from their earlier previous statements, were duly confronted with and thereafter, the previous statements of those hostile witnesses were brought to the notice of the IO. When he was examined as PW
Are your lordship, it will be 6 and
Six.
7.
7,
6.
6. Post. We have
But there
Got
is
it.
one thing in the PM report, just now I have seen, page 53. The opinion of assistant surgeon as to cause of death, sub-assistant surgeon. Death was due to septicemia as a result of injuries sustained over body as described. All injuries were antemortem and caused by sharp pointed weapon except injury number 1, which was surgically made. However, to review the exact nature of injuries, opinions of treating surgeon is advised. So
that
here,
was not there.
that was not there.
No, I have just recorded the
Yes,
contention.
lordship.
No, that's I just seen this the treating surgeon
Not
has not
saying
been.
that what MSBI has said. No case. We have considered we have given our consideration to the submissions of advanced burial and council part of parties. First of, we have also gone through the materials available in the case records of sessions case number
20 of the
28
2008.
of 2018, in original. First of. It is apologize to refer, at first, to the relationships of the deceased, the accused appellant and the prosecution witnesses, PW1, PW2, PW3, and PW5. Those are. The deceased was the father of the accused appellant and the informant as PW1. First of PW2 is the sister-in-law or is the wife of PW1 and the sister-in-law of the accused appellant. Full stop. PW3 is the mother of the accused appellant and PW1 There's informant, and and she was the wife of the deceased. Full stop. PW5 is a cousin brother of
Thank you.
the accused appellant and a nephew of the deceased. Full stop. Well, PW1 are deposed to the effect that the accused appellant was his elder brother and he was the informant. Full stop. He had deposed that the occurrence took place at around 5 a.m. when he was sleeping in his house with PW2, PW3 and Pusto. And his father, Thaneswar Hazarika, was staying at the house of his elder sister, Deepamoni Hazarika, whose house was about, whose house was nearby, beyond 5-6 other houses. Pusto. He had deposed, he had, in his testimony, he had stated that he woke up from sleep after hearing hue and cry raised by his father, and he saw his father lying in a ditch in front of their house with blood oozing out from his stomach. Pusto. PW1 had further stated that the accused appellant was at that point of time grabbing his father. Then a call was made for 108 ambulance. Pusto. PW1 had further stated that he took his father to Samaguri Primary Health Center at first, and his father was in a state of consciousness at that point of time. God, brother, grabbing my father, not Bishop. And his cloth was full of mud. Exhibiting the affair as EXT1, PW1 stated that his father expired after 16 days while undergoing treatment at the GMCH. Uh, where The prosecution had, at that point of time, declared PW1 as hostile, hostile, and sought permission from the Planet Court to cross-examine him. Post. Para. PW2 in her testimony had stated that the occurrence took place in May 2017, when took place on one Sunday in May 2017. Occurrence took place on one Sunday at around 5-5:30 AM in May 2000. She had stated that they got up from sleep, woke up from sleep on hearing hue and cry outside poster. At first, PW1 came out of the house and she followed him. On coming out, she saw her father-in-law, we didn't make it a disease, lying in a ditch with injuries. Was the PW2 also stated that she did not go near her father-in-law out of fear. She saw the accused appellant who was also standing nearby her father-in-law. PW1 then called for ambulance service, 108 and took her father-in-law to Samaguri Hospital, wherefrom he was referred to BP Civil Hospital, Nagaon. PW2 stated that her father-in-law expired at the GMCH while he was undergoing treatment. Stating that she also stated that the police recorded her statement on the date of the occurrence itself. At that stage, the prosecution declared PW2 as hostile and sought permission from the Planet Court, trial court, to cross-examine her. Para. PW3, the mother of the accused appellant and the wife of the deceased, in her testimony, stated that her husband died after 16 days of occurrence. As regards the incident, she stated that at the relevant time of occurrence, she was sleeping inside her house. And her daughter-in-law, we need to make a PW, PW2, took her out and showed her husband who was lying wounded at that point of time. Full stop. She has further testified to the effect that her husband was in a condition to speak at that point of time. Full stop. Same thing at that stage, the prosecution was right. PW5. Para. In his testimony, had stated that at the relevant point of time, he was in his paddy field. It was at about 10 a.m. on the date of the incident, he returned home from the paddy field. Full stop. He had stated that he only heard that the accused appellant quarreled with the deceased. Full stop. He had also stated that the police did not ask him about the occurrence. Full stop. At that stage was right. Para. After declaring the aforementioned prosecution witnesses, PW1, PW2, PW3, and PW5. The prosecution cross-examined them. Full stop. From the trend of cross-examination, it has emerged that suggestions were put to them in respect of their previous statements made by them before the police. Full stop. For the purpose of appreciation, few of the suggestions put by the prosecution to these witnesses can be referred to. Full stop. Suggestion was put to PW1 to the effect that he stated in the FIR Exhibit 1 that the accused appellant picked up a quarrel with the deceased over the matter of compensation for land acquisition. Full stop. Further suggestion was put to PW1 to the effect that he, in his previous statement before the police, stated that the accused suddenly brought one dagger from inside the house and indiscriminately assaulted the diseased, resulting in grievous injuries on the person of the diseased, and as a result, his stomach came out. Full stop. Suggestion was also put to PW1 to the effect that he had deposed falsely, suppressing actual fact to save the accused appellant, who is his brother, elder brother, from the consequences of the crime. Full stop. Para. In respect of PW2, the first suggestion put to her was to the effect that she, in her previous statement made before the police, stated that she and PW1 woke up from their sleep on the relevant morning when the accused appellant picked up quarrel with the deceased. Full stop. The second suggestion put to this witness was to the effect that she, in her previous statement, stated before police that she saw the accused appellant going inside his house and bringing a knife, to severely assault the deceased indiscriminately in his stomach. And when the deceased tried to escape, the accused appellant chased him, causing injuries with the knife, as a result of which the intestine of the deceased came out. Full stop. Third suggestion was put in the form that she had deposed falsely to save the accused appellant, who is her brother-in-law. Full stop. To the other two witnesses, that is PW3 and PW4, the prosecution side suggested that they, in their previous statements made before the police, had stated differently, and they had deposed before the court different in order to save the accused appellant, who is their son and cousin brother, who is the son and the cousin brother respectively. Post. Whether after this cross-examination part carries any value? Don't need to refer, I think. Because of this cross-examination, I don't think cross by defense has any value.
Hmm.
Let me see that. The a reference can be made to the cross-examinations of the prosecution witnesses by the defense side. In brief, a reference, in brief. During their cross-examination, all the prosecution witnesses denied about the events mentioned in the affair. PW 1 had mentioned that when the accused appellant was grabbing his father, he did not see any instrument in the hands of the accused appellant. He had stated that nobody at the time of the incident, alleged incident, nobody came near the place of incident. His elder sister, Deepamani Hajorika, in whose house, the disease was staying overnight, accompanied him to take his father in the injured condition to the hospital. So his father stated that the affair TXT1 was written by a different person and he did not read the contents of the affair. His father stated that the facts stated in the affair were not true. PW2 in her examination, also denied, like PW1, of seeing any instrument in the hands of the accused appellant at the relevant time. She denied seeing anyone assaulting her father-in-law and causing injuries to him. In her cross-examination, PW3 stated that she saw her husband lying by the side of the road in front of their house. So at that relevant point of time, there was no other village person as it was early morning. she stated that she did not see she had not seen who caused the injuries in the stomach of her husband, as she had not seen the occurrence herself. All the prosecution with all the four prosecution witnesses, that is PW1, PW2, PW3, and PW4, denied of making no, PW4 in his cross-examination denied of making, sorry, PW5 denied of making any statement to police. Yeah. Before full stop. At this stage, it is not. It is noticed that the occurrence took place, the alleged occurrence took place on 21/5/2017. Full stop. And the occurrence took place in the morning hours of 21/5/2017. Full stop. The Thaneswar Hazarika, the deceased Thaneswar Hazarika sustained injuries on his person, and he was first taken to Samoguri Primary Health Center, and thereafter to the Nagaon Civil, BP Civil Hospital, Nagaon. So finding his condition critical, he was taken to the Guwahati Medical College GMCH, Guwahati, wherein he was undergoing treatment till 3/6/2017. Full stop. He expired on 3/6/2017 at the GMCH. Full stop. After his date, the postmortem examination on the dead body of the deceased was performed on 4/6/2017 by PW4 at the Department of Forensic Medicine, GMCH. So, PW4, who was serving as demonstrator at the GMCH at a relevant point of time, has deposed had deposed that he performed a post-mortem examination in reference to GD entry, Bhangagar Police Station case, Bhangagar Police Station GD entry number 63 dated 4/6/2017. Full stop. The on during autopsy, he found the following injuries. Page 70. Page 70. 1, 2, 3, 4 injuries, huh? 70, 80. A2, A. In his examination in chief, he has exhibited the postmortem examination report as exhibit 2 and and stated that in the PME report he had recorded his opinion that the death was rate of the disease was due to septicemia. With the PME report, as a result of injuries sustained over the body. Full stop. In his, he has, he is, full stop. He had stated that all the injuries were antemortem and caused by sharp weapon, except injury number 1, which was surgically made. Full stop. In his cross-examination, PW. Four, correct question, eh? 4. Stated that the surgical operation was done when the patient, when the disease was alive, and septicemia resulted as infection spread or spreaded, spreaded into the whole body. Full stop. The infection was due to the injuries. Full stop. From the postmortem report, examination report, EXT 2, it can be noticed that the disease sustained a number of inside wounds in the stomach, and
Lordship, 3
in the left arm.
left arm, 3 injuries.
According to the autopsy doctor, PW4, such wounds were caused by sharp pointed weapon. Few of the wounds. And the disease and those injuries were antemortem. Full stop. It was due to infection which spread into the whole body from the disease died of septicemia. Full stop. The issue therefore is who had caused the incised wounds on the person of the deceased. Full stop. Hey, 1976 board SSC 233. 76 board SSC 230. Was died. No, Oh, Highland. We'll come back then.
Well, the correct spelling is spread, not spreaded.
That is why I had some
I'm
doubt.
sorry, my lord.
Absolutely. Evidence Act wrong. Evidence Act. Section 154, 154. The matter of hostile witness is traceable to Section 154 of the Evidence Act. Wherein which permits a party to question its own witness. Full stop. As per subsection 1 thereof, the court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. Full stop. As per subsection 2 thereof, nothing prevents, nothing therein shall disentitle the person so permitted to rely on any part of the evidence of such witness. Thus, Section 154 confers a judicial discretion on the court to permit cross-examination. And such discretion is to be judiciously and properly exercised in the interest of justice. As the law is otherwise will settle that a party will not normally be allowed to cross-examine its own witness and declare its own witness as hostile, unless the court is satisfied that the statement of the witness exhibits an element of hostility or that he has resiled from a material statement which he had made before an earlier authority, or where the court is satisfied that the witness is not speaking the truth, and it may be necessary to cross-examine him to get out the truth. Full stop. It is wide in scope, and the discretion is entirely left to the court to exercise the power when the circumstances demand. Full stop. In Sri Robindra Kumar De versus State of Odisha, reported in 1976, 4 FCC. it has been observed that a witness should be regarded as adverse and liable to be cross-examined by the party calling him only when the court is satisfied that the witness bears hostile animus against the party for whom he is deposing, or that he does not appear to be willing to tell the truth. The court, before permitting the no, তাহলে কুশলীয় দিলে নি তুলসী After referring to Ravindra Kumar De, Supra, and other decisions in the field, a three judges bench in Kuji, alias Surendra Tiwari, versus State of Assam, State of Madhya Pradesh, reported in 1991, 3 SSC 627, has observed that the evidence of a prosecution witness cannot be rejected in toto merely because the prosecution choose to treat him as hostile and cross-examine him. Full stop. The evidence of such witnesses cannot be treated as effaced or washed off the record altogether, but the same can be accepted to the extent their version is found to be dependable on a careful scrutiny thereof. Full stop. It is equally well settled that the evidence of a, it is also settled that the evidence of a hostile witness would not be totally rejected if spoken in favor of the prosecution or the accused, but it can be subjected to close scrutiny and the portion of the evidence which is consistent with the case of the prosecution or defense may be accepted. First of how the evidence adduced before the court shall be appreciated by the court would depend on the facts and circumstances of each case. First of reverting back to Para, as we have found that the prosecution witnesses who were declared to the prosecution witnesses, PW1, PW2, PW3, and PW5, who were declared hostile by the prosecution and were examined by the prosecution. Madam, where is this? Madam, where is this? Wait. Were given suggestion on the basis of their purported previous statements made before the police under recorded under section 161 CRPC. Post up. Section 162 CRPC bars use of statement of witnesses recorded by police except for the limited purpose of contradiction of such witnesses as witnesses. Full stop. The statement made by a witness before the police under section 161 CRPC can be used only for the purpose of contradicting such witness on what he has stated at the trial as laid down in the proviso to section 162 within bracket 1 CRPC. The statements under section 161 CRPC recorded during the investigation are not substantive pieces of evidence, but can be used primarily for a limited purpose, colon 1, of contradicting such witnesses by an accused under section 145 of the Evidence Act, semicolon, 2, the contradiction of such witnesses also by the prosecution, but with the leave of the court, semicolon, and 3, the re-examination of the witnesses if necessary. The court cannot suo motu make use of the statements of police not proved and ask questions with reference to them which are inconsistent with the testimony of the witness in the court. Most of the words in section 162 CRPC, quote, if duly proved, unquote, clearly show that the record of the statement of witnesses cannot be admitted in evidence straightaway, nor can be looked into, but they must be duly proved for the purpose of contradiction by eliciting admission from the witness during the cross-examination and also during the cross-examination of the investigating officer. The statement made before the investigating officer can be used for contradiction, but only after strict compliance with section 145 of the Evidence Act, that is by drawing attention to the parts intended for cross-examination. The attention of the witness is to be drawn to that part, and this must reflect in his cross-examination by reproducing it. If the witness admits the part intended to cross-examine him, it stands proved, and there is no need to further proof of contradiction, and it will be read while appreciating the evidence. Full stop. If he denies having made that part of the statement, his attention must be drawn to that statement and must be mentioned in the deposition. Full stop. By this process, the contradiction is merely brought on record comma, but it is yet to be proved. Thereafter, when the investigating officer is examined in the court, comma, his attention should be drawn to the passage marked for the purpose of contradiction, comma, it will then be proved in the deposition of the investigating officer, who again, by referring to the police station, will depose police, by referring to the police state, will depose about the witness having made that statement. The process involves referring to the police statement and calling out that part with which the maker of the statement was intended to be contradicted. Full stop. If the witness was not confronted with that part of the statement with which the party, after declaring the prosecution, after declaring the witness as hostile, comma, wanted to contradict him, then such statements made to police is to be treated as not proved in compliance with section 145 of the Evidence Act, comma, that is by drawing attention to the parts intended for contradiction. Full stop. Within bracket, REF, TK Mishra and another versus State of Uttarakhand and another. Para. Reverting back to the facts of the case in hand, comma, it is found that the prosecution witnesses, comma, PW1, PW2, PW3, and PW5, who were declared hostile by the prosecution, comma, were not confronted with their respective statements purportedly recorded by the police, by the investigating officer, IO, under section 161 to prove the contradiction, nor their statements were marked for the purpose of contradiction. Were read out to the investigating officer, comma, PW 6. Full stop. When neither the hostile witnesses, comma, PW1, PW2, PW3, and PW5, nor the investigating officer, comma, PW6, were confronted with the statement and questioned about it, the hostile witnesses apostrophes statements recorded under section 161 CRPC cannot be looked into for any purpose much less to discredit for any purpose, including for the purpose to discredit the testimonies of PW1, PW2, PW3, and PW5. Full stop. Para. If the as the relevant parts of the testimonies, the hostile witnesses PW1, PW2, PW3, and PW5 are left out for consideration because of the nature of inadmissibility, comma, the what are left out are their testimonies made in the course of their examination in chief. Full stop. Comma, already recapitulated herein above. Full stop. From the testimonies of these witnesses made during their examination chief, comma, what can be stated to have emerged is that in the morning hours of 21/5/2017, comma, the accused appellant was found with his father, comma, Thaneswar Hazarika, in an injured condition, and with wounds in his stomach and other parts of his person. Full stop. Though the accused appellant was found with the injured at the relevant point of time, comma, in the absence of any other supporting evidence, comma, it cannot be held that one cannot reach a view that it was only and only the accused appellant who was the assailant. Full stop. The prosecution had failed to knife, whatever, to seize the knife, to seize any weapon with which the disease was allegedly assaulted. Full stop. From the deposition of the IO, no, sorry, the investigating authority did not examine any other witnesses from the neighborhood of the neighborhood, though from the sketch map exhibit 4, And from the deposition of the IO exhibit 6, PW6, it has emerged that the place of incident, there are houses nearby the place of occurrence. Full stop. Which where the prosecution witnesses, comma, who said that he was in a conscious condition. The deceased, after the alleged occurrence on 21/5/2017, comma, was alive till 3/6/2017, undergoing treatment during the interregnum. Full stop. At the GMCH. The learned trial court in the impugned judgment and order had observed that the IO, PW6 did not take any step for recording the statement of the disease during the period from the date of occurrence till his death. With the further observation that had the statement of the disease been recorded by the IO, it would have been of great assistance to the prosecution side to further its case. Regarding complicity of the accused appellant in the alleged incident resulting into the injuries of his father. Anything left out?
No. The PW3 said that
Ah.
he was alive.
That is what. And PW1 also.
One also.
One also said.
One and three.
It has not emerged from the met. '70 was not in a condition to speak. Most of the investigating officer also had not also examined any of the treating doctors, any of the doctors who had treated the disease during a period from 21/5/2017 to 3/6/2017. On the other hand, the prosecution witnesses, PW1 and PW3 had stated that the disease was in a state of consciousness. In view of the above discussion, and which No evidence. Two. No evidence emerging that it was the accused appellant who had assaulted the deceased, resulting into his death. After
After,
who had assaulted the deceased on 21/5/2017, resulting finally, ultimately into his death on 3/6/2017. Beyond reasonable doubt, comma. This court, we are of the considered view, we are of the unhesitant view that the prosecution has failed to prove the case against the accused appellant beyond any reasonable doubt. And as such, the accused appellant is entitled to the benefit of doubt. Consequently, this court has found merit in this appeal, and accordingly the same is allowed. The conviction and sentence passed against the accused appellant by the learned trial court in Sessions case number 20/2018 is set aside by acquitting the accused appellant. Full stop. It is stated in the bar that accused appellant is in custody. Therefore, he is to be set at liberty forthwith, if he is not, if his custody is not required in connection with any other case. Full stop. And what is the observation to be made in respect of the amicus? What is the fees and all nowadays? A appreciation or appreciation assistance, and I don't know, I have not any increase in the fees. Earlier I did 7,500.
7,000 something, not sure.
7,500
Yes,
earlier.
earlier. At present, I don't.
I am not saying in criminal matters
Not
for a long time. Whether there is any increase.
that I don't have any idea. What.
Of
so that
check
is-
with those. With you. The records of the Sessions case number so and so be sent back forfeit.
my lord, a direction to the superintendent of jail, Central Jail, Nagaon.
That will go
It
to
is-
the registry.
It is out.
নহয় জানো? But you will get it on Monday. Having holidays. All right.
Please, your lordship. Lordship, I seek adjournment in the matter, your lordship.
You go in April then. In April. In April.
Your lordship.
No objection.
Yeah.
Saying that
Any
April-
April, you don't have any object. Your lordship.
Fourth?
In April.
Yeah, fourth.
Yeah, fourth. Fourth
Should
of
they
April.
date any day after Bihu vacation? Because this
After-
court will not be sitting in a later part of this month.
Fourth is before Bihu.
This is assigned to dispense.
Yes,
18th, your lordship.
that will be too long.
Okay, 18th,
He said after
PK
Bihu.
Bora. Learned Council
NN
for the-
Datta.
Huh?
NN Datta. NN Datta, your
Oh,
lordship.
and then the Learned Council for the petition has sought an adjournment. So Mr. Central Government Council, A. Fukan, Learned Central Government Council for respondent number 1, MSD Gupta, Learned Council for the respondent number 2 and 3. W. Ahmed,
W. Ahmed on behalf of Beach Chaudhary.
W. Ahmed, Learned Council for the respondent number 4 are present and has not objected to the prayer made by Mr. Dutta, Learned Council for the petitioner, as sought for by the Learned Council for the parties. The prayer made on behalf of the petitioner is allowed as sought for by the Learned Council for the parties, lays the case on 18th.
Much obliged.
Lordship, the interim order may be directed to continue.
Interim order?
There is no interest.
Oh, I'm sorry.
I don't
Yeah,
think
I'm
interim order is there.
Sorry, your lordship. I apologize, your lordship.
Items 2 to 4.
That's what I might.
May it please your lordship. Lordship, I am praying for a humble submission for 5 minutes before my learned friend begins. And that would be found to be important, lordship. Lordship, this whole petition is founded on a fact that the petitioner, respondent number 4 was appointed and he did not join as a secretary, lordship. But lordship may refer to annexure 9, page 75 of my year. That will make the picture very clear. Entire petition is founded on falsehood, misrepresentation of facts, and suppression of facts. Annexure 70, page 75.
Page
We'll
17.
put even legal provisions later on, lordship, but first the facts. Lordship, the petitioner had brought in, his case was founded on a meeting of the managing committee on 7/10. This is the meeting of resolution of the managing committee on 9/10. This was not brought before the court.
Page
Page 75 of my affidavit.
75 of you.
This was not brought before the honorable court, lordship. It says the petitioner had not only joined, they were so elated with him, his joining, that they gave him all the responsibilities. His signature is there on the I. And this particular resolution was not there before the court. Page 75.
Yes.
Annexure H.
Mhm.
Members present, there were 9 quorum plus the 10th secretary himself. 9 members of the committee were there, BOD, and I.
Then secretary means you.
Yes, lordship. 10th was.
Hmm.
This is the on 7/10 resolution number 1, lordship. First, the meeting of the managing committee of Bikrampur Cooperative Society Limited was held on 9/10/21 at 11 AM Saturday in the office of the society's premises. And in the meeting, the following resolutions were discussed and unanimously adopted. Resolution number 1. On 7/10/21, C. Abhijit Chakraborty has been appointed as secretary of the Bikrampur Cooperative Society as per office letter by memo number so and so dated 7/10/21. The attention of the departmental authorities have been drawn to the fact that a new secretary is required to maintain correctly the accounts in spite of the absence of any records of accounts of the society, which the member register, cash book, day book, stock book, banker. These are not there yet. That was here. That's why he was appointed. Resolution number 2. After a thorough discussion in the meeting, the departmental authority was requested to collect and hand over all the records as well as the BOD from Sri Sanjay Kumar Burman, the former secretary to the newly inducted present committee, present secretary Sri Abhijit Chakraborty, as per rules. The kind attention of the department is drawn by the society to this aspect. It is to be mentioned that Sri Sanjay Kumar Burman was supposed to submit all the relevant documents to the society within 3 days. Till date, no records have been submitted in the society. Furthermore, the previous secretary did not make any contact even on phone, even over phone. And we are also unable to make any contact with him. As a result, the activity of the society has come to a standstill dormant state. Resolution number 3. After a thorough discussion in the meeting in respect to resolution number 1 and 2, the officer in charge Bihara Police Outpost was apprised about it, and the same is forwarded to the District Register Cooperative Society Silchar. Resolution number 4. It was not possible to recover the sale book from the salesman, even after personally asking the salesman of the society to return the sales book. It is resolved that the new secretary of the society has already been appointed, and as such, the commodities of the society like rice, flour, sugar, etc., which have been allotted in the name of the society should be collected by the secretary. The kind attention of the department authorities has drawn to in this regard. Resolution number 5. It is also discussed and resolved in the meeting to reopen the sales. This is something sales retail center of the society. The kind attention of department authorities has been drawn in this regard. Resolution number 6. The chairman and the newly appointed secretary has been vested with the responsibility to deal with the court cases of the Bikrampur Cooperative Society Limited as per letter number so and so dated Silchar on 27 September 2021, issued by the Food and Civil Supplies Authority. It is to be mentioned that the supervising officer of the society has not inspected the society even for a day. So, resolution number 7. It was resolved in the meeting to constitute the vigilance committee in the name of the Bikrampur Cooperative Society, and the departmental authorities have been informed about this aspect. A vigilance committee could not be constituted although a meeting was held on the subject. As per bylaw, the present total member of the executive committee is 9 only. The appointment of more members to the society is required to be made subject to the due permission of the Department of Society.
I have forgotten the basic facts actually.
Lordship,
You have taken me to directly that.
yes, Lordship, I'll just apprise your Lordship.
I have lost track of for what purpose the petition was filed.
Just apprise your Lordship. My friend will correct me. Lordship, this petition was filed by petitioner. There
are two petitions, right?
Yes, sir.
I have taken with me 9/25.
Yes. 9:20.
9/25, 2022, right?
Lordship.
What have been challenged here in the writ petition? That is by Mr. Sinha.
Yes.
The order of registrar,
1 minute.
we have removed the secretary. Then secretary has
Bikrampur Cooperative Society represented by chairman
chairman.
Bilaluddin Borbi.
Hmm.
Okay. Let me just
Yes, ma'am. Yes, ma'am.
now you are representing Mr. Abhijit Chakraborty.
Yes, sir.
Removal secretary.
Is there any dispute about the status of Mr. Bilaluddin Borbi?
No, Lordship.
Hmm?
Email from me was
That question did not
your
arise.
signature.
No, there is no dispute.
That was not raised. ma'am.
Okay, no, not
Yeah.
in dispute.
Yes, ma'am. Page 39 Annexure 8. This was challenged by the
1 minute.
Abhijit, my lord.
Okay, let me. Who is Sanjay Kumar Bormon?
Sanjay Kumar Burman was the departmental secretary, my lord.
Okay, departmental secretary.
Yes.
9:25.
He's a senior inspector
Mhm.
of cooperative societies.
Okay, where is that 7/10/2022? Withdrawn?
Yes, my lord. That
It was
is-
withdrawn.
Yes, my, that is your lordship will find at page 35, annexure 7.
Page.
Sorry, not that.
No.
Withdrawn is on 1/12/21, page annexure 7.
Huh?
And his appointment was
One
on,
minute, one by one.
yes, my lord.
Sanjay Kumar Burman was withdrawn.
Yes, my withdrawn, my lord.
Which page?
Oh. No, withdrawn,
Okay.
withdrawn, his
Accordingly,
withdrawn,
okay.
my lord, was,
Abhishek Chakraborty was withdrawn.
no.
Okay, 17. Let us see page 17. Seventeen is formation. Formation. What is this, page 26?
Yes, his appointment, for appointment, resolution was adopted.
We discussed regarding post of secretary of the society. Chairman of society, no, how is the secretary? There is no secretary. The prolonged desire. This is the appointment of Abhijit Chakraborty.
Abhijit
Yes,
Chakraborty, my.
And the annexure that I had read out was the next day's resolution.
Okay. That is on 17/2021, Abhijit Chakraborty was appointed.
Yes, Lordship.
Now we can go to 75.
75. The
Just for,
allegation,
just for chronological events.
just before that, Lordship,
Six.
the allegation here is that he never joined. And I am attempting to show he not only joined, he actively
Okay.
participated.
So this meeting was held on
9/10.
some কাগজ এখন দেখছো সৰু এখন দিলাম এখন দিলাম। Then this was appointment was on 17.
Yes, Lordship.
Then page 75. 75 meeting was held on 9/10. Right?
Yes, Lordship.
9/10.
The number 10 is my name, Lordship, in that list.
Within 2 days, another meeting was held.
Yes, Lordship.
Okay.
Where my signature was taken, that I was present in the meeting.
Their allegation was that you did not join.
I did not join. That's why my appointment was cancelled. That is a basic dispute, Lordship.
Why this page 31?
Lordship. Page 31. That was a complaint against by some club members that was given to the department of a club, and that had no cause later, and they also most of them withdrew it. But basic dispute here, Lordship, is that he had never joined.
Now, come to page 35. This is a meeting.
Page 35. That is on 112. Lordship, this
No, we are on the dates, sequence.
second, that is 112.
So that I can have a better idea.
This is 112.
That resolution was taken on the ground that you did not join.
Yes, Lordship. There's no quorum, Lordship, 6 members only.
Okay. What is this police case? What is this police case?
Police case is for making forgery of seal and signature of the chairman
Against whom?
against this Abhijit Chakraborty, my lord.
Who filed?
This society has filed.
Where is the FIR?
Yes, FIR is at page 44.
Registered.
Yeah, registered, madam. FIR is registered. Category PS case number 28,
What is the page number?
28 under section 409 and 468 IPC forgery, ma'am.
409.
Yeah, but 409, I don't know why,
Hmm.
but 468 is there.
Okay. Mr. Taludar, page 45. 45. Yes. The subject matter. Hearing as per appeal petition filed by Abhijit Chakraborty under 49(2)(b. That speaks otherwise, 49(2)(b. Please see, you have a copy of the act? Yes. But, in a later part, he said in the matter of appointment of second.
That may be a typing mistake, man. Because
49(2)(l) or what?
yes,
L, man, 12.
it should be 2L.
Now 48 is the impugn order.
Yes.
Hmm?
Yes, madam.
Okay, let us read page 48.
Whereas an appeal petition dated 14/12/2021 has been filed by Sri Abhijit Chakraborty under section 49(2)L of the Assam Cooperative Society Section 7 against the cancellation of his appointment and the advertisement of new secretary of Bikrampur SS Limited. And whereas the appeal has been admitted under section 111 of the Assam Cooperative Society Section 7 and date of hearing has been fixed on 10/1/2022 and accordingly called the person concerned for hearing. On the date of hearing, Sri U.B. Deka, Junior Joint Registrar of Cooperative Societies, Urmat Ali, Chairman of Bikrampur SS Limited, on behalf of the Board of the Director of Bikrampur SS Limited and Sri Abhijit Chakraborty petitioners were present, heard them and perused the concerned record. And whereas on perusal of the record and hearing the parties is observed that number one, the petitioner who has been removed from the post of secretary was not given prior notice for his removal, nor he was given any chance for his defense. Number two, only 6 members have signed the resolution of the Board of Director meeting held on 7/10/21, which is short of requisite quorum 8 members of the Board of Directors as required under section 43(5) of Assam Cooperative Society Act 2007. And whereas the Board of Directors of the Bikrampur SS Limited has contravened the provisions of section 35(2) of the Assam Cooperative Societies Act 2007.
1 minute. Yes.
And whereas no natural justice was given to the petitioner prior to his removal, the advertisement published for appointment of secretary is liable to be set aside. Now, therefore, I, Sri Manoj Kumar, IAS, Registrar of Cooperative Societies, Assam, in exercise of power conferred under section 49(2)L of the Assam Cooperative Societies Act 2007, do hereby set aside the advertisement published in the newspaper and allow the Abhijit Chakraborty to continue as the Secretary of Bikrampur SS Limited until further order. This order comes into force with immediate effect.
So, which is to be tested,
Yes, madam.
which Mr. Taludar,
I understand.
which is to be tested. Question is, what thing is to be tested?
First,
Now I have understood the sequence of events. Now I have jotted down, so I have understood. Now I am putting the query to Mr. Talukdar. You are fighting, you two are private. Private.
Yes.
Mr. Talukdar is state. Now I am putting a query that which is to be tested here. Because this board, its resolutions are not to be looked into in the exercise of judicial review. This is not a public function. Discharging public duty. Quorum, not quorum, we are not into that. Because it is a private body. Why should we look into that? Somebody is holding a meeting and High Court will be interfering. Quorum, not quorum, we are not interested. Let them do their own thing. Now, this authority, firstly, to exercise power under 111, it has to be an order
Yes.
passed by a government servant. First thing,
That is correct.
right? That is not there.
I was also thinking about that.
Now come to 49.2. He has exercised 49.2. L. That relates to chief executive, his powers, functions and stuff. Now, chief executive is normally known as secretary.
Well,
If it is an institution like Apex Bank or something, cooperative bank, so and so, there the man is known as chief executive officer.
officer, CEO.
Better designation, better looking. But here it is secretary.
Secretary.
But otherwise, he is the chief executive. But he is to be appointed by the board.
Board.
If it is not, the society does not have any government stake. I think
Yes, correct. Here, by the board.
by the board,
Hmm.
as simple as that. Now, let us read 49.2. The chief executive shall be under the general superintendent's direction and control of the board and exercise the following powers and the functions, namely L. In case of dispute between the chief executive and the board in any matter, the decision of the registrar shall be binding on the board. Now, this any matter also includes the matter of appointment and cancellation or not. That is the issue.
Hmm.
Is it not?
Malot, I did not get it. Malot, please.
49, let us read the heading first.
Chief
Chief
executive.
Executive Officer, his powers and
And
function and staff.
Hmm.
There shall be a chief executive by whatever designation called. So it can be secretary also. Of every cooperative society to be appointed by the board
Or by the state government.
or by the state government. In the event of appointment of the chief executive by the board, he shall be a full-time employee of the society, full-time.
Full time.
So it is under the board.
Hmm.
Because C, if you read C,
See.
where the government, state government stands guarantee for repayment of any loan secured from any financial institution, the chief executive may be appointed by the state government.
That is not dispute.
So it is, there is no dispute.
Right.
Now come to subsection 2.
Hmm.
The chief executive shall be under the general superintendent's direction and control of the board and exercise the following functions, namely A to K, there is no problem.
Problem.
Now here, in case of dispute between the chief executive and the board in any matter, the decision of the registrar shall be binding on both. Now question is, in any matter, quote unquote, covers the matter of appointment and cancellation of appointment of the secretary himself.
The language is otherwise. In case of dispute between the chief executive and the board. So if
In any matter.
yes, so therefore here what it Malot contemplates, in my understanding, Malot, that he is a chief executive or a secretary who is in the board or Malot in the society, and there is a board. So dispute is going on between them. So
Not
it is
regarding,
not
prima facie, not regarding his appointment,
removal or like that.
appointment.
So here when the chief executive is Malot
Suppose
functioning.
he is taking some decision regarding, suppose PDSI,
Yes,
but board is saying, no, this cannot be done in that manner.
Yes.
there are disputes, suppose.
Yes,
Then registrar can decide,
yes. In case of a dispute,
right?
so the executive should be there, a secretary should be there, and both vis-a-vis, my lord.
Vis-a-vis, it is direct confrontation between them,
Yes.
not
Yeah.
regarding his appointment.
Yes, that is what I understand the
I also
plain language.
plain language. Now, that can be because what cannot be done
Yes,
directly
Yes.
cannot be done indirectly.
Yes.
For that purpose,
that is correct.
your opinion is come to page section 92.
92, yes. In fact, my lord, that was I was about to refer to your lordship.
Because any dispute
Hmm.
touching the business of a registered society, comma, other than a dispute regarding disciplinary action taken by a society against an employee of the society. This is out. Or of the liquidator of a society shall be referred to the register for decision.
Yes,
Right. So discipline, this matter of appointment and cancellation of appointment is a disciplinary action against an employee. He is a full-time employee.
Correct.
So other than that, other matters can be referred. This 49(2)L
Yeah.
is relatable to this
dispute.
dispute. Now, if you come to section 93,
93, settlement
The-
dispute.
registrar shall, on receipt of a reference under section 92, decide the dispute himself or authorize any other government official to decide the dispute. Or he can refer to arbitrator. Right? B, C. Then thereafter also subsection 2, after referring to arbitrator, he can again take back. Then subsection 3.
Whether the registrar is satisfied that a party to
So that is different.
him to with intent to defeat or delay the execution. That is
So now the legality and validity of the impugn order in the context of 49(2)L and section 111 are to be tested.
Yes.
Because it is challenged.
that is correct. My lord, since
And because Mr. Talukdar, I'm asking for your opinion is that it has huge ramification.
yes, correct, correct. It have a ramification, I understand.
Then
Since your lordship is also bound by the language of the statute, my lord, because it cannot be interpreted otherwise.
thereafter,
Yes. You, other cases, 49(2)L, my lord, it will be amounting to open a floodgate. Yes.
that other and also otherwise.
Yes, yes.
And if this is decided one way or the other, if it is that no, register does not have the authority and jurisdiction as regards the matter of appointment or cancellation, then there will be huge reduction.
Yes,
But if it is says that yes, he has power, there will be huge
both sides,
tsunami.
floodgate.
So
But my
that
lord,
is why I am asking your opinion.
yes. My lord, in fact, my lord,
Otherwise, facts are clear.
yes. Lord,
Maybe that body in the meeting held on a board held on 1/12/2021 was not having quorum. We are not into that because that is a private meeting, private body. Private body, just because it is registered under the Act, it does not get the color of state
correct, correct.
to be amenable under Article 12.
Sorry, my lord.
So, remedy, because repetition is challenging that order. That is why I asked all of you, because at that point of time, Hurmut Ali was chairman.
Yes, madam.
Now, Chairman is
Bilaluddin Barbhaiya,
Bilaluddin.
whose name is at 7 in the.
Now he has become chairman. So writ petition is validly instituted. What do you say then?
My lord, in respect of this exercise of power, my lord, since the registrar has exercised a power and I'm representing him,
That is why.
yes. My lord, in fact, I would.
Your act is
Yes.
coming into question.
Yes. Now, my lord, my respectful submission would be, apparently, my lord.
Let me, before that, let me see the challenge.
Well.
What has been impugned? That is impugned.
That is impugned, my lord.
That is the impugnment.
What is the ground you have said? No authority.
That is not the ground, man.
Huh?
No such ground is taken.
The ground is not maintainable. There is a order passed by the registrar is not.
Who is it?
maintainable.
Who is it? Divorce the rule, para 16. Arbitrary and illegal. Okay, one ground is there. Now, how much saved?
If I make a small. This 92 lordship, it seems to make a difference between a disciplinary proceeding and non-disciplinary proceeding. 92 will touch only non-disciplinary proceeding, other than disciplinary proceeding. And non-disciplinary proceeding also will be covered by 49(2)(l). It speaks of all, that means there are two kinds of disputes only.
Satisfy me that your dispute,
but-
that
but
matter
before-
of cancellation and appointment. Because as soon as your appointment is cancelled, you no longer the chief executive.
If I join, I need to be
You no
terminated.
longer remains chief executive.
My submission is, it's very clear, Lordship, I have read it Annexure H. I had joined and actively participated. After that, there's a question of cancellation come. I should have been terminated because of my.
No, that is not a question, Mr.
Before my inefficiency.
No, that is not the question. Question is exercising the power by the registrar.
Yeah, I understand that. The issue seems to be
Your,
that
we are
whether,
concerned with your appointment, your cancellation of appointment, you misappropriating money, your lodging of FIR against you. We are not very much concerned with that, those issues. Since this order has been challenged, it has to be tested in the context of section 111, 49(2)(l). Public order publicly made is to be tested on the ground assigned in the order.
my one idea submission, Lordship, to bring that to the Honorable Court, Lordship, he has adopted a path of falsehood, Lordship.
Who?
Said, the petitioner, Lordship, has said that I was appointed and the appointment was cancelled because I did not join.
No,
Whereas, Lordship, they have suppressed their fact that I had joined and actively participated.
Mr.
Can a petition
no,
founded
Mr.
on
Goswami,
falsehood
you are not
succeed?
getting the point.
I am answered, but factually it's a false petition.
We are not in the factual thing.
I understand, Lordship. I have understood, Lordship. Legal Lordship is talking about legal.
Right order or wrong order. That will be, I think, within the province of some other forum perhaps.
But coming to this court with unclean hands, who did,
What unclean?
he did not make a correct submission. His petition is, he
These are disputed facts.
disputed facts, but then Lordship,
We will not decide that clean or unclean.
documents, Lordship, this becomes almost admitted facts. When I said these are his documents, he's the secretary, they maintain the resolutions, and resolution says he has joined and actively participated.
No, this is a very, I don't know, but for me, it appears to be
Yes,
some,
there are definitely
has some
the legal implications, I understand rightfully.
legal implication.
But then on factual aspects, he has not come with clean hands.
That is different. He is
That,
challenging.
that, Lordship,
That is disputed, you have brought this material. Now, I don't know whether they have controverted it or not.
Yes, my, we have filed FIR, my lord. The FIR has been filed.
FIR, they
against
filed
this.
left and
Yes,
right
sir,
lordship.
for this only.
Okay.
They filed FIR against the previous secretary also. nothing
FIR is
after
filed
that they
only
filed.
for this one. I
Lordship-
can prove it also, my lord.
No, Lordship, I'll just make one submission. They had filed FIR
Address
because the
me on this
government.
one only. No, no,
They
address,
can keep filing FIRs left
we
and
are-
right against everybody, Lordship.
we will not waste any time on this.
That should not be given to you early.
On this, because he has said he has lost the affair. End of the matter, it is a
He has
dispute.
lost the FIR against the other secretary also, government employee that too.
My lord,
Who?
They have lost. The results I was reading, they have filed a FIR against the government employee, the previous secretary.
Sanjay Kumar. Yes, Mr.
One
It's
line.
there, I was reading it from the, yeah, I came to know only from the resolution, that they filed a FIR against the.
Mr.
previous-
Talgar, we have already beyond time.
yes, my lord, only one line. I'll not burden your lordships anymore. Now, apparently, my lord, the mention of this section is wrong. 49(2)(l) and 111, my lord.
Okay.
Could not.
We assume that if he has power
Yeah.
relatable to a particular statutory provision, wrong mention of a wrong provision
Correct.
will not
Yeah.
vitiate the order.
Yes, my lord.
So take me to the statutory
Yes,
provision.
correct, my lord. In fact, my lord, if I argue restricting my submissions only in respect of this case, my lord, only in respect of the facts of this case.
Facts no, here
No.
on the statutory.
No,
Statute.
what I am on, that if 92, my lord, is interpreted, 92 says, other than a dispute regarding disciplinary action. Now, if the action which is taken, if it does not fall within the contour of disciplinary proceeding, then perhaps, my lord, the exception which has been carved out will not apply in the present case. Now, the question would be, if, my lord, a person is ousted without
No, this is not disciplinary because word is
Yeah.
disciplinary action.
disciplinary action,
not
obviously.
killing.
No, my lord, action will culminate. So therefore, what I'm trying to say, a disciplinary action can be taken if a proceeding of show cause, my lord, whatsoever, because disciplinary proceeding cannot come out of blue.
Okay, Mr. Talukdar.
My lord, this is
Yes.
my
No, I'm giving you food for thought.
My lord,
There are perimeteria provision
no, I have to find out, my lord, correct.
in other
Statutes, my lord.
cooperative acts of
Yeah.
all the states,
Yeah.
most of the states, perimeteria provision,
Yeah.
and there are decisions
Decisions to
on
that
it of the Supreme Court.
My lord.
Supreme Court, perimeteria provision, and the decision. Neat. Now, if it goes, and it is relatable to 49(2)(l), suppose, or not. 49(2)(l), what cannot be done
No, correct.
directly,
No, no,
cannot be done indirectly.
no, correct.
Then other than this and section 111, whether there are any other provisions.
I do not find,
Uh-huh.
but that is why, my lord, I started with these words, that I am restricting
Sure.
submission in respect
Sure.
of the facts.
Sure,
So if your lordship holds,
whether action,
if your lordship holds that this does not fall within the, my lord, the expression of disciplinary action, because it did not precede by way of any proceeding or any notice, because the, my lord,
then Mr.
no, my lord,
Talukdar,
I'm just-
no, there are.
I'm
there-
thinking
no,
aloud,
no,
my
no.
lord, I may be wrong.
Yes,
my
for thinking aloud, I'm just adding
Yeah.
fuel to the fire.
lord.
While thinking aloud, you also take into account
Well.
only 3 categories of employees are entitled for disciplinary proceeding,
That is correct.
right? One is civil servant. Second is employees governed by rules and regulations of a statutory body. Third is industrial workmen.
Three categories.
Apart from that, nobody, as a matter of right, is entitled for any
No, that is-
disciplinary proceeding.
no, that is correct, my lord. What I'm trying to submit. Lordship is
So
absolutely-
we are already beyond
Yes,
time,
yes,
Mr.
yes.
But Mr. Talda, I have some difficulty in the sense that I'll not be sitting next week division meet. thereafter I'll not be sitting. It can be only in the second, first week.
Lordship has heard it, Lordship. Keep
No,
it,
no,
my
I'll
lord.
keep it.
Lordship.
It will be listed.
Yes.
It is already marked in my name,
Yes, yes,
so it will be listed in.
yes. I'll try to, my lord, further satisfy because this issue, my lord, now it rests on a gray area. Lordship will settle it because this type of cases are coming. So Lordship will settle it, my lord.
This is to be done also.
My lord.
Time has come.
My lord.
Though in 1992 it was settled.
Recession now. Correct. No, recently, my lord, what happened? There is a, my lord, coordinate bench judgment. In fact, the honorable court said that since PDS articles are distributed and under the Food Security Act, so therefore it is a, my lord, it discharges public function,
Society.
society, and therefore, my lord, the removal by the board, and it was held that it is, my lord, instrumentality of the state. That was held.
Bring that.
Yes. And in fact, that was taken up to the division bench. Division bench having regard to the fact that, my lord, it falls within the domain of employer-employee relationship contract. So mandamus perhaps cannot be issued. For in that context, my lord, it was stayed. There is a division bench judgment.
9 judges far back has said employer-employee relation
Yes.
is a contract of personal nature.
Yes.
Reinstatement is not possible.
Yes. GTV, on basis of GTV, my lord, that was allowed.
Sinha, petitioner. S.K. Talukdar, Standing Council Corporation Department for the State Respondents, R. Goswami, Learned Council for the Respondent. First up, Punina Commerce Society, it was just now, today I have got the sequence of it. Leo Kunya Commerce Fix. Fifth of it.
Approved. Public.
Lordship, after 8th, I'll be outside. 58, I'll not be insist.
Then it will go beyond
After view.
Vihu.
So 58, I'll not be insist.
Then it will be, it can be 9th also. 9th.
Yes, 9th, I'll be
Ninth?
back.
I have no problem.
All right.